Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. At the end of 2 days of hearings that were conducted before Judge Stephen Hippler, the court thanked the parties for their time and their attention. And then he stated words to the effect of, "I don't know if I'm going to grant a Franks hearing or not, but email me dates of your availability within the next 3 weeks." We have done multiple prior presentations on the Indie Zone podcast, as well as here on YouTube, on what a Franks hearing is. If you have not had an opportunity to do so, please listen to those prior presentations, because this is such an important issue to both sides, whether or not Judge Hippler does not grant Mr. Kohberger a Franks hearing. Briefly, the term Franks hearing is named after an important United States Supreme Court case of Jerome Franks versus Delaware. And what that motion, what a Franks motion does, is it challenges the truthfulness, the veracity, the legality of a warrant affidavit, an affidavit that is sworn under penalty of perjury by law enforcement to obtain a warrant. Over the course of the past few days, there have been so many matters that have happened in this case. We've seen the return of the media coalition, and to address the hearings of the 23rd and 24th, which would be conducted behind closed doors, closed to the public, which would be open to the public. Ultimately, a schedule was set up, and it was determined that certain matters related to witness testimony, for not just that motion to suppress, but also potentially for a Franks hearing, which is rather unusual, because testimony and live evidence like that does not usually happen until or unless a Franks hearing is granted. But what the court said in his explanation was, I don't want to have it assumed that just because we're taking this testimony that there will be a Franks hearing. But once that testimony is out there, it's like toothpaste out of the tube, as they say in litigation. It's information that's out there. So that was a sign that the court, at least in my opinion, which I give pursuant to the First Amendment, was thinking seriously about granting this motion. We had the hearings that went ahead, and for the court to say, provide me with dates in public, as he did within the next 3 weeks, I thought might be another clue that perhaps he's leaning towards granting this hearing, because how things go, especially a high-profile case like this, where the court has acknowledged that there's not just local attention in Idaho, there's national attention and also international attention. The court could have just had his judicial assistant email the attorneys and say, just provide me with a few dates in the next 3 weeks for a potential hearing. This is not to say the court's granting it, but just give me a few dates. For Judge Hippler himself to say it in open court like that, knowing that there was enormous interest in the case and that many, many ears would hear him, I thought was rather unusual. But What I want to do is to return to what I call the blueprint for our case of Idaho versus Kohberger, governing further criminal proceedings and notice of trial setting. This is the pre-trial and trial order that Judge Hippler put out in October that scheduled the hearings that you've been watching or listening or been talking about on the 23rd and the 24th of January. Those hearings were set. The dates were within this filing. This tells us that Voir Dire, which I believe is the official start of this trial, that is, the process of jury selection, will occur July 30th at 9 o'clock a.m. If we go through this document, you'll see that it sets deadlines such as some of the things that have already happened. The DP motions, they were filed, the court entertained them at oral argument, and he submitted rulings. All of those, as you recall, were denied. Then we see the discovery motions. There was a discovery motion that was entertained today by Judge Stephen Hippler. There were multiple ICR Rule 12 motions. These are the multiple suppression motions that have been pending since the end of 2024, November 14th to be exact, because this order told us that the motions, the initiating papers were due November 14th, the responses by the state were due December 6th, and then the replies were due December 20th. So that was the briefings. That's when they were closed, and then you see the hearings were set for the 23rd, and if necessary, continuing into the 24th at 9 a.m., which has happened. In looking back and looking forward now, what is coming up due in the next 3 weeks, which brings us up to the middle part of February? We see right away that motions in limine are due by February 10th, 2025. Responses, March 3rd, replies March 17th, and a hearing on the motions will be held on April 3rd and continuing on to the next day, similar to what we saw with the Rule 12 ICR motions, if necessary. So we are rapidly approaching trial, and what needs to happen for this case to be prepared for trial. What is a motion in limine? Now, we know that a motion is an application for a court order. So this blueprint, this pretrial and trial order, tells us that both sides are to submit their motions in limine by February 10th. That is the deadline. And then the state and the defense file their responses to each other's motions in limine, and then the same with the replies. A motion in limine is Latin. It literally means motion at the start, and that is trial. They are used pre-trial, and it is basically to seek an order from the court that something should be kept out of the case. Now, this is different from what you just saw with the motions to suppress evidence that's relevant to the case, that has been brought through discovery to the defense's attention, such as the motion in limine to prevent certain records, data from Apple, Amazon, to come into the case. This is something entirely different, and it may not be related to any of the evidence regarding this case at all. It may be something else. Let's just say if someone had a prior conviction if that conviction for substances is deemed to be possibly prejudicial, there might be too much prejudice if the jury were to hear that the defendant in another type of a case, such as for burglary or armed robbery, was convicted for substances. That might be the topic. Judge, I don't want any mention of this matter, that my client had a problem with substances, that he was arrested and he was convicted at trial for using substances. That might be a topic for the motion in limine. So it's something that will never be discussed while the jury is present and always has to be discussed before the case. You've got to go in, you've got to file the motion, you've got to make the application for the court order. The court grants it, then no mention whatsoever can be made about that topic before the jury. That's how close we're getting to trial. That may be why, if he's leaning toward at least granting the hearing, why he made that statement in open court for dates within the next 3 weeks. We are going to be having a scheduled session tomorrow as a wrap-up for what we learned during this really important week in this case. A lot happened. That involves not just the testimony, what you saw, the motions to suppress and to compel, but also involving the media coalition that came out of their prior position as interveners and asked to be heard as interested parties this week. Please join us for our live 3 p.m. Eastern Standard Time on this YouTube channel. Until then, this is Kathy. Thank you for joining us here today.